The Commission was always of the position that a complaint is a complaint, it's not a position, and that a complaint must be closed in the form of a decision. Be it a decision rejecting the complaint, be it in a decision addressed to the complainant. But I think there is a big misunderstanding of not only that it is not a petition, which was never the position of the Commission, and that it's not on what the procedural regulation proposal is based, but also what are the right to be heard and the due process rights. Right to be heard, it's to be granted to the person who will be adversely affected by the decision. When an authority acts upon the complainant is not adversely affected by the decision, but will take advantage of the state acting against the controller. Having said that, bearing or taking due account of the fact that we are in the area of fundamental rights and that it will only improve the correctness of the decision, the complainant is given the access to the document where the allegations against the controllers are spelled out. And the so-called preliminary findings. So it's really unique that, and also in comparison to the laws of the member states who are providing for variety of inclusions of the complainants, that the complainant will so clearly understand what is the case, the authority will advance against the controller, and the complainant can make comments and on it, as we call it, makes its views known. But again, a decision addressed against the controller is not a decision adversely affecting the complainant. Therefore, the use of the term of right to be heard and due process rights is not correct. It's also the Charter who is saying that it's right to be heard against the person. Now, whomever will be adversely affected by it. And again, the Schupa judgment does not change anything in this respect. The proposal that the Commission was not based on such a misunderstanding of a notion that allegedly the complainant is a petition. It is not. So let me come back to some of the comments made by Elena. And I fully take the point of Fernando, and we are very much supporting the deadlines and the provision of the deadlines by the Parliament and by the Council. We are trying to work out something that will really speed up the whole process. Now, I will address 2 points made by Elena, and before doing that, I will just say that while providing for the proposal, the Commission looked broadly at what didn't work and where are the problems. And it's always so that those involved in the problems are saying that the problems are always with somebody else. Well, it's never the case, and probably the problems are spread throughout. Also, as concerns, and here I'm going back to this dialogue between the authorities. Indeed, we saw that on the one hand, there could be in the identified cases, or there were cases where there was maybe not enough outreach from the side of the lead authority, but there was also the activity or the outreach from the side of concerned authorities was not sufficiently proactive. In order to remedy these insufficiencies, we provided for this summary of key issues where, on the one hand, lead would need to be very clear, very early up, what it wants to do and to which extent. Here I'm addressing the question of scope in the cases of complaint-based investigation, but also it imposes on the concerned authorities, in our proposal, the obligation to act upon it, to not just to sit and wait that the whole process goes through and the lead authority presents the draft decision, where it's very difficult to address, for example, alleged lacks concerning some parts of the investigation. So the question of the scope. From our point of view, addressing the question of the scope later on, what the EDPB and EDPS are pleading for, actually leads to extension and prolongation of the procedures, because an authority will be at a very late stage obliged to extend the investigation and again hear the parties. Therefore, we are very strongly pleading for agreeing on the scope of the investigation very early on. This will lead to quick remedies for the data subjects. So and here are several steps in the whole procedure which EDPB wants to change, which actually extend this possibility to comment on the scope, what we find not really leading and incentivizing closing the proceeding early. Concerning the hearing, there I must again say that we as a Commission, we are very surprised that an authority defending and representing one fundamental right, not an authority, a body, and the national data protection authorities, have such a difficult understanding of other fundamental rights, namely due process right, for example. And we also do not share the view that hearing the parties only on the basis of relevant and reasoned objections, as it is the case now, bearing in mind that some of these objections are not going to be taken up by the board, is not very telling. And we think that from the point of view of good administration, a body representing and defending one fundamental right should also embrace other fundamental rights, due process, and provide for meaningful right to be heard.